Go ahead and open the webinar. Good morning, everyone. We'll go ahead and get started in another minute to allow folks to join us. So I see folks are joining us, so we'll give folks another minute or two to join us before we officially get started. Good morning, everyone. We'll give folks one more minute before we officially get started. We still see folks are joining us. So one more minute and we'll be officially getting started with today's webinar. Okay, let's go ahead and officially get started. Um, it looks like we have over 200 people joining us, so that's exciting. Hello, everyone, and I want to welcome everyone to today's session. The CSU Office of the Chancellor, in collaboration with the California Community College Foundation and the Immigrant Legal Resource Center, welcome you and thank you for joining us. My name is Dr. Ana Aguayo Bryant, and I will serve as your moderator along with Alonso Garcia from the Community College Foundation office. We have three expert attorneys that are with us, and they will be from the Immigration Legal Resource Center, and they will be presenting on today's webinar. We have Sally Cachinita, the Deputy Director, Griselle Reese, she's the supervising attorney, and then Allison Davenport, the supervising attorney. I would like to let you know that today's webinar is being recorded and it will be available at the CSU Office of the Chancellor website and the California Community College Foundation website. Also, I would like to inform you that we are not having any closed captioning for today's webinar. So we apologize, but we will not have any closed captioning available. Also, throughout the presentation, we want to hear from you. So I know that you have questions throughout the presentation, so please post your questions through the chat box. We will be happy to address your questions. And at the end of today's webinar, we will allow for time, about 15 minutes of questions, Q&A. So those will be the live questions. And with that, let me just welcome those who are just joining us. We have additional folks who have joined us this afternoon, so welcome. And with that, let's go ahead and officially get started. And I know Sally will be the first presenter in this morning or this afternoon.
Good afternoon, everyone. My name is Sally. I'm from the Immigrant Legal Resource Center. I want to first thank the California State University Chancellor's Office and the Foundation for California Community Colleges for inviting us to be here and for hosting us to share with you today information and updates on immigration law and policy under the Biden administration. For those of you who are not familiar with the Immigrant Legal Resource Center, our mission is to work with and educate immigrants, community organizations, and the legal sector to continue to build a democratic society that values diversity and the rights of all people. We're a national nonprofit organization headquartered in San Francisco, and we train attorneys, paralegals, community-based advocates, those who work with immigrants around the country, and we inform the media, elected officials, and the public to shape effective and just immigration policy and law, and to work with grassroots immigrant organizations to promote civic engagement and social change. Next slide, please. So I'm going to provide first a little overview of some of the immigration changes so far since the inauguration of President Joe Biden, and a little preview of some of the things that are on the horizon, after which I'll turn it over to my colleague Grizel, who will go into more detail about immigration enforcement issues, and later we'll turn it over to our colleague Allison, who will talk about some of the immigration programs that are currently available and will continue to evolve and be available. Next slide, please. So first, I just wanted to highlight some of the differences between Trump's priorities and Biden's values. This will look familiar to many of you. You may recall that under President Trump, his priorities were to end the DACA program, build a border wall along our southern border, to limit legal immigration and refugees, to make the asylum process more difficult, and to target all undocumented people for deportation. Biden has stated that his values are to undo Trump's damage, modernize our immigration system, welcome immigrants, reassert commitment to asylum seekers and refugees, tackle the root causes of irregular migration, and implement effective border screening. Trump was not able to fulfill all of his priorities, nor do we know that Biden will be able to live into all of his values. However, we hope that this is a signal that immigrants will not feel so targeted and attacked under the new administration. Many feel that, many have said that Biden's proposals are very bold in as much as they could potentially, if passed, benefit far more people than have ever have benefited from an immigration program in the United States in the past. However, at the same time, many activists feel that they're not bold enough because Biden really needs to do a lot to undo a lot of the harm and damage caused by the Trump administration. Next slide, please. So let me go over a quick overview of some of the actions taken so far by the Biden administration. There actually have been many. These are just some of the highlights or some of the ones you may have heard of. So first, Biden has taken action to halt the Remain in Mexico program. This was a Trump era program that forced asylum seekers to stay in Mexico for court hearings instead of being allowed into the United States to seek asylum. He's also moved to end the Muslim and African ban, which forbid the entry of people from certain countries, mainly Muslim countries. He's created a task force to reunify families. This is really to help those families who are separated, children who are separated from their parents and their legal guardians under the Trump administration, some of whom have still not been reunited with their parents or legal guardians. Biden has committed to preserving and protecting the DACA program, which is a program to benefit undocumented young people by providing protection from deportation and work permits. We'll go into more detail about the DACA program later in this webinar. Biden has also committed to reviewing the public charge changes. These were changes made under the Trump administration in which they sought to expand and change which public benefits programs could impact some immigrants' ability to get a green card or a visa. Again, we'll go into a little bit more detail about that. We also heard that there's some interest among students about changes related to H-1B visas and H-4 visas. H-1B visas are work permits that allow foreign workers to work for American companies if they can show that they have a specialized knowledge for which that employer can't find a United States-based worker already. USCIS, the immigration agency in charge, can issue 65,000 of these kinds of specialized work visas a year, and another 20,000 H-1B visas to foreign students who have completed higher studies from a United States university in science, technology, engineering, or math, so one of the STEM subjects. H-4 visas are for those family members of H-1B visa holders, and they had been allowed to get work permits. Under the Trump administration sought to change the process for getting H-1B visas and to take away work permits for H-4 visas. What I'll say about this is that under Biden, they've actually halted any changes to H-1B processing. They're going to review the system and the policies, so everything remains the same as it has been in the past through the end of this year, and they're also restoring the ability of H-4 visas to get work permits. And finally, Biden has also made changes to border policies as well as enforcement priorities. And as I mentioned, after I'm done speaking, I'll turn it over to my colleague Grizel to go into more detail about that. Next slide, please. Okay, so before we go on to all the changes that have been proposed and could happen, we want to remind people about how immigration law and policy is changed and why some of these things may be very difficult to move in the next year or next few years. So immigration law can change through legislation and laws, that is Congress passing a law or a bill and then it being signed into law by the president. It can also be changed through regulations and rules, which is the sort of process, how these laws are implemented. It also can be changed through executive orders and actions. Those are things that the president and or his secretary or cabinets can actually change. Then little things get changed through policy memo, guidance, manuals, that actually instruct immigration officers exactly how to process these cases. And estimates are that when you look at the legislation, laws, regulations, policy memos, et cetera, there were actually hundreds of changes to immigration under the Trump administration. Therefore, it could take a lot to disentangle and reverse some of those changes. And finally, even when there are these kinds of changes, they can be challenged in the courts through litigation and lawsuits. Next slide, please. So just some examples. When we talk about legislation and laws, we're talking about things like any program that would give people a green card, what we call legalization programs that would help undocumented people go from being undocumented to having a green card, or something like the DREAM Act, anything like that would actually have to go through a law, in other words, be passed by Congress, both houses of Congress, the House of Representatives and the Senate, and be signed into law. There are things like regulations or things like public benefits that under public charge, like which public benefits count, when does it count? That can be done through regulations, and it's the federal agency in charge of that. For example, the Department of Homeland Security, who's in charge of immigration, that can make those changes. Executive orders like the DACA program or the Temporary Protected Status program, some of those things can be done through executive orders and executive actions, which are either the president or, as I mentioned, the cabinet members like the Secretary of the Department of Homeland Security. And then these policy memos and little changes to procedures that I mentioned, those can be things like implementing priorities or how people are treated or kinds of questions they're asked at their interviews. And that can also be done by the federal agency in charge. And finally, as we talked about, there can be lawsuits and litigation that could start or stop programs, and those are decided in the courts by the judges. Next slide, please. So I wanted to provide a little bit of information about some of the kinds of legislation that you may have heard about in the news, including the DREAM Act of 2021, and then also the US Citizenship Act. So the DREAM Act, many of you may have heard of before as a law that would provide a quote unquote pathway to citizenship. This is a piece of legislation, meaning that it would have to pass both houses of Congress and be signed into law to become real. It would impact, the estimates are between 1.7 and 2.9 million immigrants, depending on how it's written. And it's currently already, it actually just last week was introduced in the Senate. It has bipartisan support, meaning it was introduced by a Democrat and a Republican. And it actually, this year would be the 20th anniversary of the DREAM Act. The first time the DREAM Act was introduced was 2001. There have been many attempts to pass a DREAM Act, and the fact that there was a failure to do so was actually what led to DACA. If we can't have a DREAM Act, give us DACA instead, and that's what we got back in 2012. But let's go back to what the DREAM Act even is. The DREAM Act would provide what's called a pathway to citizenship. And what does that mean? It actually means several steps along the way, not automatic citizenship. What it would do is it would allow undocumented people to apply for something called conditional status, which they'd get for 6 years, during which they presumably have a work permit, protection from deportation. And then after 6 years in that status, they could apply for a green card, which is that piece of that card that allows you to travel in and out of the United States, and have the benefits of any other green card holder. And then after 5 years of having a green card, one could apply for US citizenship. All along the way, there would be certain specific forms people have to fill out, documents to prove that they meet the requirements for the DREAM Act. They would have to pay probably a filing fee, do a background check, and possibly interviews along the way, especially for the green card and citizenship. Next slide, please. The requirements, these are how the requirements have generally looked in the DREAM Act. They could change by the time it becomes a law. In other words, some of these details may change, but the rough sketch of what it's likely to look like is that to be eligible for the DREAM Act, the currently undocumented person would have had to have arrived in the United States before the age 16. They have to have resided in the United States for at least 5 consecutive years. If they're male, they have to register for selective service, which is the draft, which, as a reminder, even if you're undocumented, you have to register for that to qualify for one of these programs. The person has to have graduated from a US high school, obtain a GED, or be admitted to a higher education institution. And they'd have to pass a background check and show good moral character. Next slide, please. The next step after 6 years in that status would be to apply for a green card. And at that point have to meet certain requirements again. At that point, they would have to have shown they've either graduated from a 2-year community college, completed at least 2 years of a 4-year degree, or served 2 years in the US military, one of those 3. And again, pass another set of background checks and show something called good moral character. Next slide, please. Then the third step, if they so choose, would be to apply for US citizenship after 5 years of having the green card. Like other applicants for US citizenship, they'd have to show residency and physical presence in the United States, show good moral character, be able to speak, read, write, and understand basic English, pass US history and civics tests, and also take an oath of allegiance to the United States. These are the basic requirements for all of these. Occasionally, there are exceptions to these, but these are the basic requirements that you should anticipate. The other thing to anticipate for anyone who might want to avail themselves of one of these programs along the way is that you will have to document that you're eligible for all these requirements. The most important one that you could be definitely working on right now is showing that you are present here in the United States. One of the things about any of these programs is it's likely to require you to show you were in the United States by or on a specific date. So for example, for DACA, you had to show that you were in the United States in July of 2012. For some of these, you need to show you were in the United States on January 1st, 2021. We don't always know what the date is going to be. So if you can just save documentation for every month that you're in the United States, if possible, that will serve you later if you're applying for any of these programs. Next slide, please. Okay, there's also another bill that has been introduced, which is called the U.S. Citizenship Act of 2021. This would provide a pathway to U.S. citizenship for about 11 million immigrants. So the difference between this one and the DREAM Act is this one actually seeks to give green cards to every undocumented person in the United States, not just people who came when they were young before they turned 16. The requirements as they're roughly sketched out are that you would have to be physically present in the United States on January 1st, 2021, and you would get temporary status for 5 years, after which you have the ability to apply for a green card and then later apply for US citizenship. So a similar trajectory to the DREAM Act, but the timing is a little bit different for when you need to be here and how long you have these different statuses. The other thing I want to highlight is under the bullet point about temporary status for 5 years. It is very possible that these if passed, that these bills will include a fast track for Dreamers or DACA recipients or those who have temporary protected status. Basically, for those who already have some kind of temporary status that has shown their presence in the United States, it's possible the temporary or conditional status under one of these bills will be, that requirement will be met by having been a DACA recipient or a TPS holder. Next slide, please. Okay, before I turn it over to Grisel, I just want to again highlight that all of the details of these bills are yet to be worked out, so we don't know what they will look like. If any of these even become a law, the details could change. In the meantime, try to save as many documents as you can to prove that you meet the requirements for any of them. We have resources we can share later with how you would do that, but it's something to start thinking about already, even if this program takes a year or two or more to become a law. And for now, I'll turn it over to my colleague Grisel to talk more about immigration enforcement.
Thank you so much, Sally. That was very informative. So hi, y'all. My name is Grisel. I'm a supervising attorney at the ILRC, and what I'm going to talk about today is immigration enforcement and the changes that we anticipate regarding immigration enforcement under the Biden administration. So before I jump into the substance, a quick note, what do I mean when I say immigration enforcement? So immigration enforcement really refers to the manner in which our federal government identifies, detains, and deports individuals. So how do they decide who to arrest and try to deport? Is it everybody? Is it just certain people? How do they make those decisions? What changes might we expect under the Biden administration, especially when it comes down to ICE arrest, which is the area that I'm really going to focus on in this presentation. Next slide. Thank you. So before I jump into the substance, I want to just start off with a little bit of context and background. So let's talk a little bit about how it is that people get funneled into the deportation pipeline, is what we call it. How is it that ICE even identifies somebody who is potentially deportable? So taking a step back, you see this image here. Individuals can get arrested, can become arrested by ICE in a variety of different ways. We don't have time to go into all of the different ways that people might end up in deportation proceedings or might end up arrested by ICE. I'll focus on just a few of them. And if you're really interested in this issue, you're welcome to dig into our website, ilrc.org/enforcement. But a few of the ways that people are maybe more familiar with are that people can be arrested by ICE in their homes, out in the community, sometimes while they're driving places, sometimes while applying for immigration relief. And this is actually why it's really important, especially if you've had any contact with the criminal system in the past. And even just as a general best practice, whether it's applying for a green card or applying for citizenship. It's always important to get some consultation with a legal service provider. And I know that you guys have some really great resources at your disposal. So again, applying for an immigration relief, that's actually one way that people can end up in proceedings. Other things that can trigger a ICE arrest, certainly people coming in at the border, that's traditionally been a big source of how people get funneled into proceedings. And under the Trump administration, we did see an uptick in worksite raids. But these are really just a few examples. And what you see to the far left of the slide is a little pie chart. And that actually represents the #1 way that people end up in removal proceedings, especially when we're talking about interior enforcement. So not the border, but how people end up in proceedings with in the interior of the United States, like they've already been here. And there really, you know, even though I think a lot of us think of worksite raids or home raids as how people end up in proceedings, actually the #1 way when it comes to interior enforcement really is through contact with the criminal system, whether it's local jail or prison, but some type of contact is for a lot of people what ends up triggering an ICE arrest. And that pie chart actually shows you, this was a study done by TRAC several years ago, and they found that about 75% of interior ICE arrests actually resulted from contact with the criminal system. Next slide, please. Oh, next slide, please. Thank you. And so what do we expect to change under Biden? How might this process change? Who's funneled in, how those individuals are identified, how they decide to act on those arrests. So we actually do have a memo that the Biden administration issued. Folks are calling it the Pikoski memo. But before I jump into what the memo says, I want to talk about a few points. So first of all, let's just talk about the role of these memos generally, because we've had these memos issued from previous administrations, including Trump and including Obama. So it's important to know that the administration has a tremendous amount of discretion when it comes to the manner in which it decides to use its resources. So even though DHS is one of the most well-funded federal agencies, it still doesn't have infinite resources, and administrations often make decisions about how they're going to arrest, detain, and deport individuals. And so that's what this is. That's what this memo is, essentially a memo outlining how the current administration is going to enforce immigration laws. A few points is, another important point is that this memo is temporary. So the memo actually explicitly states that more longer term written guidance is pending in the future. We don't have like a firm date in terms of when we expect this, but I would expect in a series of months, several months, we'll get more long-term written guidance. And it's also important to know that this is a discretionary agency memo. It's not law. It's not a code or a statute. And what this means in practice is that the agency, ICE agents, may act in ways that go outside of this memo. And the memo actually does have a specific section that says that ICE agents on the ground can still seek people or go after people who fall outside of this memo. However, there are actually some really positive portions of the memo. While the priorities and the overall memo could definitely be stronger, there are a lot of opportunities to push for a stronger actions on the ground, so that fewer people are separated by deportation. But it is significantly more narrow than previous administrations. It's much better. Obviously, it's much better than the Trump administration, but it's significantly better than the Obama administration too. And this really is a testament to community power. So all of the organizing, everything that folks have been doing in the past years is really what has resulted in the positive portions of this memo. And then a final question is really what implementation looks like. So we have this memo, but we have a lot of questions about, okay, what is this going to look like on the ground? What does this word say? What did they mean when they said that? So this memo is currently in effect right now. It became effective as of February 1st, but right now we're still in the process of collecting anecdotes about how this is going to play out on the ground. And we're actually also awaiting further written guidance from ICE. Next slide, please. Thank you. Okay, so let's talk a little bit about what the memo says and what changes from the previous administration to now. And a quick note just on time, we don't have time to go super deep into this, but happy to answer questions. And again, our office will actually be issuing a lot of resources, including community-facing resources that will go deeper into what the memo means. So in terms of what changes, so the memo states that ICE arrests will still continue to happen, but they are going to be narrowed. So according to the memo, ICE arrests will be focused primarily on arrests coming out of jails and prisons, and even then specifically focused on individuals who fall into these three categories that you see here, specifically national security threats, border security, and public safety. But it's important to note that these are categories that ICE has made up. They get to make up who falls into these categories, who doesn't. This isn't necessarily drawn from some code of law somewhere. So these are just, so it's important to know that. Also because as members of the public, it's important to be, critical and really think thoroughly when we're seeing how this stuff is coming out. Next slide, please. Thank you. So talking just quickly about who might possibly fall into these categories. So we have these three categories: national security, border security, and public safety. So national security, the administration is saying they're going to use it against people who they believe to be involved in terrorism, spying, or other threats to national security. Again, this is a definition they're using, they're making up, and there's still a lot to be seen about who will actually fall into this. In terms of the border security category, they're talking, what the memo states is that they're thinking about people who've entered unlawfully or crossed without, who have entered unlawfully on or after November 1st, 2020. And then the last category, which is probably going to be, I think, probably the biggest category, are individuals who are currently in state county jail or state prison or federal jails who have a conviction for something that immigration law calls an aggravated felony conviction and whom DHS decides is a threat to public safety. So I'm going to stop there because this term aggravated felony is a really complex, vague, and quite frankly, misleading term of art because there actually are state misdemeanors that can trigger this ground. So all that to say that if you have questions about, oh, I have a family member or I know someone who's in state custody, who's in criminal custody and I'm worried about them being possibly handed to ICE, there it's just really important to talk to an expert, talk to a DOJ rep or an immigration attorney who can sort of help with this assessment, and also see if there's any individual advocacy that can be done. Because even if someone appears to fall into these categories, there are still ways to possibly stop that individual from being handed over to ICE and to stop that ICE arrest. So I'd like to say, get an expert, and y'all have some really great access to experts here. And the last thing I'll say on this slide is that I've really focused on how these are the categories for ICE arrests, but these categories also apply to other areas of discretion. For example, certain actions that might play out in immigration court, who is detained and released from detention, etc. Next slide. And I know that a lot of you have also seen the buzz about a moratorium on deportations, and this is something that we're kind of waiting to see, is this really something that Biden's going to do? And in that memo that I just discussed, he talked about these different enforcement priorities, but he also talked about, there's also a section that talks about a moratorium on deportations for certain types, for certain individuals. So moratorium basically means like a halt. So basically what this part of the memo was saying was that deportations of certain people were going to be stopped for a certain period of time. However, before that portion of the memo could become effective, the state of Texas sued the US government and secured something called an injunction, which is basically like a pause on that portion, on some type of action while the judge decides the underlying case. So basically what this means is that that portion of the memo, and only that portion of the memo, has a pause on it while that case continues to be litigated through the courts. Now, again, this injunction only applies to this moratorium, only that section of the memo, so the rest of it is still in action and still in effect. And also, really all this means in practice is that it's kind of just business as normal. So in terms of people and deportations being processed, but this also means that advocacy can still happen in individual cases. Someone might still have legal options in their individual case. This is really where it's important to get customized advice, but just flagging that, you know, there still might be avenues and options for individuals who might have pending deportations, but here, again, super important to get counsel. Next slide. Thank you. And then I'll just end quickly by just noting that in terms of what we should be looking out for, again, there are more long-term memos that are going to be coming out in the future. So we'll want to sort of keep an eye out for that and also see how all of these pieces are actually playing out on the ground. Watching the litigation in the Texas case is also important. But more than anything is, ensuring that people are informed and engaged on these issues, because there is a lot of opportunities to sort of steer the direction of how these things are playing out on the ground, both locally and at the national level. And I know that your generation is very social media savvy, and social media is actually a great place to get more information about these topics. So on the right, what you see is a little icon that actually comes from CJA, and also the California Dignity Not Detention Coalition. So organizations like CJA, like the ILRC, put out a lot of different materials to inform the community about what's happening on all of the topics that we're discussing today. So if you don't already, go ahead and follow us on Instagram, on Facebook, on Twitter, and that's another place where you can get up-to-date information about what's happening on all of these issues. Next slide. And then lastly, I'll keep this short for time, but just a quick note that Know Your Rights information remains super, super important, both for yourself and for your family members. The right to remain silent, to keep your door shut if ICE comes to the door, unless, because they very rarely have signed judicial warrants. And then also just knowing that you have the right not to sign anything without speaking to an attorney. So I know that you have access to a lot of other great Know Your Rights resources. Just want to flag that this remains important. And with that, I will pass it on to my colleague, Allison.
Great, thanks so much, Chriselle. Yeah, so I'm going to walk us through some updates on current policies and programs, just to give you a snapshot about their current status and what we might expect in the coming weeks and months under the new administration, and with some of the things pending in Congress that Sally described. So let's start with what's been a very hot topic for the last 3 years, which is DACA. So as we all know, since the program started in 2012, it's been hugely successful and beneficial to around 600,000 DACA recipients. In 2017, just to kind of give us, ground us and give us a little context for what's happening right now. In 2017, the Trump administration terminated the program with a bit of a wind down period. That was challenged in court. Various lawsuits challenged that termination. In January 2018, a federal court partially restored the DACA program, allowing renewals to go forward, but did not allow first-time applications or advanced parole applications. So that was kind of the status quo until last year. In June of 2020, the Supreme Court heard that legal case challenging the termination of DACA and sided with DACA recipients, saying that the termination of the program was unlawful, it didn't follow federal law, and therefore was invalid. And we were all very excited, hopeful that this meant the program would be restored. That was in June 2020. Just over a month later, instead of getting guidance from the Department of Homeland Security about how they were going to implement that decision from the Supreme Court, they issued a new memo restricting the program once again. So again, only allowing renewals, making renewals valid for only 1 year, and then limiting who could qualify for a travel permit under advanced parole. That was again subject to legal challenges. One of those cases went before a federal court in New York, and that judge issued a decision in December of 2020 saying that that memo was not valid, and therefore the program was fully restored to its original structure outlined by the Obama administration in 2012. So that's kind of been where we're at in terms of the practicalities of applying and receiving DACA benefits. Is the federal court in December fully restored the program in its kind of original 2012 version. So what are we seeing under the Biden administration? Next slide, please. As a candidate, President Biden said a lot of things around supporting DACA recipients and supporting the family members of DACA recipients, improving access to higher education. On his first day in office, he did sign an executive order on DACA, ordering the Department of Homeland Security to, quote, preserve and fortify the DACA program. Because the program was kind of fully restored at that point, given that federal court order from December, it really didn't have any practical effect on the program. The program was already operating fully at that point. So it didn't have any practical effect, but it did indicate the administration's commitment to protecting the program. It did not change the requirements. It didn't kind of expand access to DACA, but it did indicate wanting to protect the program as it is now. So let's look at what this means for DACA recipients and DACA eligible individuals. So people who have DACA or had DACA in the past are eligible to renew their case. So whether your case recently expired or expired several years ago, you are eligible to renew your DACA. It's recommended that you apply for renewal 120 to 150 days in advance of your expiration date. That way the case can be processed and you can get your DACA approval notice and the new work permit before the expiration of your current case. So renewals are operating pretty normally. It's also possible to apply for DACA for the first time. For the first time since 2017, the program is open to first-time applicants. We know a lot of, especially younger people, were waiting for this opportunity. Maybe they had just aged into the program when it was terminated, had just turned 15. They had maybe older siblings who had benefited from the program, and then it was closed by the time they reached the minimum age. We also know other folks were eligible but weren't able to apply because they had not been able to save the money for the application fee, the $495 application fee. Other folks just couldn't get the evidence together that's required. So it is an opportunity now to apply for DACA for the first time. The other thing is the advanced parole. That's the process to apply for DACA recipients to apply for a travel permit to travel outside of the United States and to return to the US. That program is also fully restored and operational. We still don't know kind of what the future of DACA is going to be. We also know that it is it's a temporary form of protection. It's not a permanent status. It doesn't lead to a green card. It doesn't lead to US citizenship. So we always encourage people when they're renewing or if they're going to apply for DACA for the first time, that they talk to a legal service provider about other and better options, more permanent options they might have under immigration law. Okay, next slide. Let's take a quick moment and just review the program requirements for those who might be considering applying for DACA for the first time. Since it's been a while since they're allowed first-time applicants, it's good to just think about who might be able to benefit from the program. First off, you have to have, your birth date has to be after June 15th, 1981. You have to have entered the United States before your 16th birthday. You had to have resided in the United States since June 15, 2007 until the present time. You have to have been physically present in the United States on June 15, 2012. That's the date the program was announced. And at the time you're presenting your DACA application. On June 15, 2012, you have to have not had any lawful immigration status. So that could be folks that maybe entered the United States without documents and had never applied for any kind of benefit or protection, or it could be people that maybe entered with a visa, but that visa expired and they were technically undocumented, did not have lawful status on that date. There are education requirements. Obviously for your campuses, community colleges, CSU campuses, being enrolled in those campuses is automatically, you would meet the education requirements, but the education requirement is much broader. And I think there's been a lot of misperception about DACA being just for people who are studying at the university or high school students. It is for folks who have either are working on their GED or have a GED, people who have a high school diploma or equivalency, people who are in vocational school, who are at adult schools. So it's a much broader requirement. And I think a lot more folks could benefit from the DACA program if we can get the word out about this more generous educational requirement. There's also a background check that applicants have to go through, and certain criminal issues can bar you, but not all of them. So it's important to also consult with a legal service provider about your eligibility if you've had contact with law enforcement. Okay, so those are the requirements to apply for DACA for the first time. And again, you do have to have the minimum age of 15. There is an exception for people who are currently in immigration court proceedings or have an order of deportation, but otherwise you do have to be 15 at the time of applying for the first time. Okay, let's, next slide. Let's talk for a moment about advanced parole. So again, this is a travel permit that's available to people who have an approved DACA case. You apply for the travel permit. You have to say when you're going, where you're going, for how long you plan to stay, and for what purpose. Advanced parole for DACA recipients is limited to travel for purposes of education, employment, and what's called humanitarian reasons. Humanitarian reasons can be anything from the applicant needing medical care in another country, visiting an ailing relative, a death in the family, something like that. And even though, you know, this is again available to DACA recipients after, you know, not being an option for quite some time, we do want to caution people to really think carefully about their travel plans given the global pandemic. There's a lot of different travel restrictions depending on the country you're visiting. Some countries have closed their borders, limited the number of flights in and out of their airports. Some have quarantining requirements upon arrival. And of course, people need to take precautions to stay healthy and safe while traveling abroad. So it's really important to talk with the legal service provider about your plans, to do a little research about the country you're planning to visit, and make sure you can travel and return safely and without delays. It's important to return before the expiration of your travel permit. So it's also a good idea to request on your application for advanced parole, maybe a little bit more time than you even want to be abroad, just so you have some wiggle room in case a flight is canceled or you encounter any other difficulties in your return trip to the United States. Okay, so that's just a quick snapshot about a couple aspects of the DACA program. What's next is, you know, I think the DACA roller coaster ride we have been on for the last several years is continuing, unfortunately. Even though the legal challenges to the termination of DACA were successful, there is one pending lawsuit that is challenging not the termination of the program, but the legality of the program itself. And this is a lawsuit brought by Texas and several other states saying that DACA is not legal, that the executive branch doesn't have the authority to establish a program like DACA. That lawsuit is still pending. There was a hearing in Texas in front of the federal judge in December. We're waiting to hear what the next steps are out of that case. It could be that the judge issues an order sooner rather than later, either positive or negative. It could be that that case gets set for trial, which would mean a much more extended kind of legal process. And it also might be that the Biden administration becomes involved in that litigation. And so there might be a little bit more time needed to work out what the role of the Biden administration will be. So that is kind of a looming threat to the DACA program. Anything that happens in terms of that court's decisions, there's likely to be further appeals, and there will not be any immediate effect on DACA recipients. So if you currently have DACA and say the judge says DACA is not legal, it wouldn't mean your DACA gets revoked. You would still have your DACA valid for the period it's been approved for. So we'll try to keep you updated on that legal challenge. In the meantime, again, we did see, you know, there's a possibility of some other executive orders. So again, we saw President Biden issue this first day order saying he wanted to protect and fortify the program. The Department of Homeland Security has a new secretary that's in charge of that department. So there may be additional executive orders coming from the secretary of the Department of Homeland Security. That could be anything related to expanding the requirements of DACA, expanding the benefits of DACA. It could be things about access to federal financial aid. We just don't know, but there could be more executive action beyond what we saw President Biden sign on his first day in office. And then, as Sally mentioned, there's also a couple of possibilities around legislation. So there's this larger piece of comprehensive legislation, the Citizenship Act of 2021, that has a fast track for DACA recipients. So they are immediately eligible for a green card. There's also separate bills like the DREAM Act that she described, which was just introduced last week. There's kind of a lot of different factors that come into play that might shift, what types of benefits are available and what kind of process DACA recipients and DACA eligible young people could be eligible for. Okay, next slide. Let's go ahead and take a pause on DACA, and we're going to shift over to TPS. So TPS is temporary protected status, and it's a form of protection for people from certain countries that are experiencing ongoing armed conflict, a natural disaster, or some situation where it's not safe or in the best interest to send nationals of that country back to that country. Countries are designated by the Secretary of the Department of Homeland Security as a TPS country. Next slide. Right now, there are 10 countries that are designated for TPS, and those 10 countries are on your screen right now. The Trump administration said that they were going to terminate TPS for the 6 countries on the left-hand side of your screen. So on the white side of your screen, those are the 6 countries that were identified for termination by the Trump administration: Nicaragua, Haiti, El Salvador, Sudan, Nepal, and Honduras. Overall, there's about 300,000 TPS recipients currently in the United States. The vast majority are folks from those 6 countries, the largest being El Salvador, which has almost 250,000 people enrolled in TPS El Salvador. So the Trump administration said these countries were going to terminate TPS. That's also been the subject of litigation. So currently their status has been extended through October 4th, 2021. So they continue to have TPS protections, work permits. Nothing has changed for them. On the right side of your screen, on the blue half of the screen, are the 4 countries that have been reauthorized for TPS status. Those are Syria, Yemen, Somalia, and South Sudan. And President Biden most recently reauthorized Syria as a TPS country, extending protections for Syrian nationals through September 30th, 2022. So those 4 countries are kind of more in a safer zone, a more stable situation in terms of their TPS protections. Next slide. So folks who are from any of those 6 countries and currently have TPS, those countries are still kind of operating under this order by the Trump administration saying they're going to terminate the program, but it has been extended through October 4th, 2021. There's no need to apply to renew TPS. It's an automatic extension of TPS protections, and their work permits are also automatically extended through October 4th, 2021. Folks with TPS in those 6 countries have the option of applying for a new work permit if they so choose. It may not be worth it given the processing time for a new work permit and the expiration date that's looming out there. So most folks, what they do is print out a copy of the notice in what's called the Federal Register and show that at their place of employment to indicate that they have an extension of their current work permit through that deadline of October 4th, 2021. In terms of, let's go to the next slide. In terms of next steps, especially thinking about those 6 countries that were designated by the Trump administration for termination, President Biden has said that he is going to review the current designations, and he may protect and extend them. We already saw an order extending protections for Syria. That seems, it seems like, you know, there is some sense of him looking at which countries are coming up for expiration, reviewing those countries, and then potentially extending protections for an additional 18-month period. It's also possible that we will see additional countries designated as TPS countries. We aren't 100% sure what countries those might be, but the Biden administration has indicated that it's considering Venezuela as a potential TPS country. And just like in the situation for DACA recipients, there's some different, you know, paths that might be available to TPS recipients over, you know, depending on what action there might be in Congress. So that broader legalization bill, the Citizenship Act of 2021, would of course be one opportunity for TPS recipients. Just like for DACA recipients, it does have a fast track to a green card or permanent residence for TPS holders. The other possibility is there would be a standalone bill. So just like there's the DREAM Act for DACA recipients or DACA type eligible folks who came to the US as young people, there's other standalone legislation that would benefit people who have TPS. And previously it was introduced as the Promise Act. There's also the Secure Act. So we may see either a comprehensive bill, but we may see some standalone legislation that benefits TPS holders. Okay, so that's what we know for now about TPS. Very briefly, next slide. There's also a related type of protection called DED, Deferred Enforced Departure. It's like TPS, it's a little less protective than TPS. It's something designated by the president, not by the Department of Homeland Security. And right now, there was DED for Liberian nationals that was first designated in 2007. The Trump administration terminated DED for Liberia and made that effective January 10th, 2021. So just last month, we saw President Biden in the first week or so of his administration, sign an order reinstating DED for Liberians and extending that protection through June 30th, 2022. There's also something called the Liberian Refugee Immigration Fairness Act that allows people who were enrolled in DED or other Liberian nationals who've been present in the country since 2014 to have kind of a fast track to a green card to permanent residence. So there's a really great opportunity for Liberians and their family members to apply for something under the LRIF legislation. President Trump, the day before the inauguration of President Biden, did sign an order designating Venezuela for DED through July 20th, 2022. This could be hugely impactful. As we know, there's been a huge increase in the number of Venezuelans entering the United States over the last several years. So the estimates are somewhere between 95 to 200,000 folks that could benefit from a DED type program. As of now, there's no guidance from USCIS around DED for Venezuela. Since it's only been a couple of weeks since the Trump administration made that decision. So we don't know if DED program will become available to Venezuelans or if we'll see the Biden administration designate Venezuela for TPS. So a lot of movement there. But the fact that President Biden has reinstated DED for Liberians does make me think that maybe he's going to be reviewing and extending protections for other countries that either were slated for termination, TPS termination, or for Venezuela. Okay, I'm going to leave that there. Let's move on to a couple of other quick updates, and then we're going to take your questions. One big threat that arose under the Trump administration was a proposal to increase immigration application fees and to eliminate fee waivers for low-income applicants. So just to give you an example of what this proposal, was outlining to do, it would have increased almost every kind of application fee. It would have increased it. For example, in the case of naturalization, when a green card holder applies for U.S. citizenship, that application cost is currently $725. It would have increased it to $1,170. So a really astronomical increase in the application fee for citizenship. It also would have eliminated many kinds of fee waivers. When someone is applying for an immigration benefit and is low income, it would have eliminated that option in many cases. So again, taking the example of citizenship naturalization, instead of allowing low-income green card holders to apply for a fee waiver of that application fee, it would have eliminated that completely. So only people who could have paid that $1,170 could file for U.S. citizenship. And it would have done something, very historic and a break with our tradition in terms of promoting access to asylum, which is imposing a $50 application fee for asylum applicants. This was subject to litigation. So there was, several lawsuits challenging these changes, and it was in fact halted. There should be some negotiated settlements around that coming in the next few weeks. And so we do think this is a threat that has passed, hopefully. I don't want to say that definitively because the litigation is pending, but the Biden administration has indicated they are not interested in continuing with that proposal. So current application fees and the availability of fee waivers remain the same. Nothing has changed, and we don't anticipate any changes in the foreseeable future. Okay, next slide. And then let's just give a quick update on asylum, refugees, issues at the border. Sally talked a little bit about this at the very beginning in terms of what executive actions we've already seen. First off, there has been a big shift in border policy. The first is that the Migrant Protection Protocols, the Remain in Mexico program, that program has been terminated. So that's the program where someone who is seeking asylum at the southern border is basically registered, issued a number, and told to wait in Mexico to have a hearing before an immigration judge. So that program is now closed. That means anyone seeking asylum at the southern border will not be put into that program and will be kind of processed according to our more normal asylum processes. However, there's about 60,000 people that were enrolled in the Remain in Mexico program since it was initiated. Those folks have been in refugee camps waiting for an asylum hearing. So it's very troubling human rights conditions for those folks, especially given the pandemic and their exposure to the virus and to their vulnerability to violence. And so it's unclear at this point what processes the Biden administration is going to put in place to deal with the folks who are already in the program and have been waiting in Mexico for their asylum hearings. So we'll provide you an update about that. Also very important is the family separation policy has been terminated, and the task force to reunite the 600 plus children with their families has begun. So something we need to watch. Also, very concerning. Kind of a human rights mark on our country's history. And then finally, we are anticipating an increase in the number of refugees admitted into the United States. Under the Trump administration, the number of refugees who were screened for asylum abroad and then allowed to enter the US and resettle as refugees in the United States dropped dramatically. In the last year, they capped the number of refugees admitted to about 15,000. That's a historic low for our refugee resettlement program. The Biden administration says that they want to increase that cap back to its normal levels or even beyond that. A target number is 125,000 refugees being resettled per year in the United States. So that program is going to take a while to restart, right? Because people are screened abroad, issued travel documents, and then travel to the United States and are resettled here through a refugee resettlement agency. So it will take some time for us to actually see folks being admitted and resettled into the United States. But I think it is something that will get restarted in the coming months. Okay, next slide. And then finally, one final note about asylum. You know, the asylum process, asylum law, kind of the standard for people who are seeking protection from persecution was really attacked relentlessly under the Trump administration. Both the process they go through, the standard they're held to, the benefits they can get while they're waiting for a decision like a work permit, all of that was subject to attack after attack. So we're seeing a real review of those asylum processes, as well as kind of how asylum officers and immigration judges make a decision on an individual's asylum application. So I think we'll have some more announcements regarding asylum coming very soon, but it is a very complex area. So some of these things are going to take some time to roll out. Okay, so next slide. And just to sum up, you know, there's a lot of changes in terms of programs and policies shifting under the new administration. There's a lot on the horizon in terms of potential congressional action. So it's really important the community has access to good, accurate, up-to-date information, and they're also getting legal advice from a qualified legal service provider. So I'm going to turn it over to Ana and Alonso, who are going to share some resources about legal services available on the different campuses.
Thank you, Allison. Thank you all the attorneys that presented on this very important topic. For the CSU, I wanted to share, you know, we have 23 CSU campuses from San Diego all the way to Humboldt, to the northern part of the state, which is our Humboldt campus. All 23 campuses have assigned staff members who work with our undocumented students or students from mixed status families. We have all the resources and support services available to the students. So when a student comes to our campuses, there is a team that welcomes them and helps them navigate the campus. I would encourage you to visit our website, our calstate.edu website for undocumented resources for undocumented students. You could find the campus, you know, who's a liaison at every campus. And also we have our immigration attorneys. We have 4 agencies that are working with our campuses, and we're all virtual, just like all, you know, the CSU and the community colleges and the UC campuses. We're all virtual. We continue to be virtual. So know that our attorneys that are working with our campuses, they're meeting with our students, they're providing support to our families, and are making, you know, addressing a lot of the questions that students have, especially with their immigration status. So with the CSU, please, you know, take time to review our website, look at the resources. And also with the CSU website, if you're a community member and might not have a student, or if you're not part of the CSU, our website also has resources for the community. So please, you know, click on the link that has for community resources, and it'll direct you by county of who's available in your area to provide you with resources. And with that, let me have Alonso now present on the community colleges.
Good afternoon, everyone. Thank you, Ana, for the introduction. For our community colleges that are participating in this webinar, there are 65 regional hubs throughout the state of California that will provide free legal consults to all students, faculty, and staff. I will chat a link to that here shortly, but any student associated with the community colleges is able to benefit from these resources. As all of our attorneys have expressed today, it's the best time to find out what legal remedies are available to you and to those looking for a change of status. Currently, our attorneys are able to support students, faculty, and staff. And once you find the link, please look at what's available to you regionally. So our state is broken down through 7 regions, and you'll find which campus is closest to you. There's also a tool that will help you connect with the legal service or the undocu liaison at each one of the campuses, and I'll chat that link here shortly. So those of you that are looking to continue your education, have some questions around the disaster relief funding, financial aid, whatever that may be, you can connect with this representative at your campus to answer some of those questions. And now we have about 20 minutes or so for Q&A. And I'd like to bring up Allison again, just to kind of share additional insight on DACA, if there's someone that arrived here after 2008. Are there any talks about how the DACA program might change and morph with this new administration?
Yeah, great. That's a great question. So for right now, the initial requirements for DACA are the same as they were under the original program in 2012. Now, there are a lot of advocates working to persuade the Biden administration to expand those requirements. Since DACA is an executive action, it falls within the executive branch, right? It doesn't require congressional action. To expand those requirements so that it's more generous and more people can qualify for the program. So things like not having that age cap that you had to be born after June 15th, 1981, making the date as of which someone has to prove their presence in the United States more recent. So when the program was announced in 2012, they made it go back 5 years to 2007. But here we are now in 2021. So that's a really big lift for a lot of people, is to come up with evidence of their presence in the United States since 2007 until now. We're talking, 14 years at this point. So shifting that date to maybe 5 years from now, so that it would be, not so burdensome to collect those documents, and also people who maybe arrived more recently would be able to qualify. So yes, there are some efforts to try to make the program more generous, at the same time working on some of these legislative fixes, the DREAM Act or this comprehensive immigration reform, to make sure that also would be more generous and more inclusive than the DACA program was. But for right now, those requirements are kind of very firm. So, we've had some questions in the chat about, I meet all of the requirements, but I entered the US in 2008, or I didn't come before I was 16, I came when I was 17. Those are very kind of strict requirements. And if you don't meet one of those, it's, very unlikely your case would be approved, and you'd just be losing your application fee and the time and effort you spent in kind of collecting that. So it's really important to work with the legal service provider to just get screened, make sure you are in fact eligible, make sure you have all the evidence you need to prove that you do meet each of those requirements. And then if you're not eligible for DACA, what other options you might have under immigration law. And then to also be connected with someone so that if you do hear about something happening in Congress, one of these proposals actually passing and becoming law, you can go back and then see if you might be able to benefit from that program.
Great, thank you for those clarifying answers, Allison. I think, immigration is so complex, and that just having that point of contact, and again, both the CSUs and the community colleges provide legal support services to students, faculty, staff, and family members. So it's important to get those screenings, make sure that, that the fees that you're paying are actually going to hopefully support some form of status change. Just a quick follow up on like H-1 visas. Not sure, either Allison, Sally, can you provide some context around that?
Are you referencing the question in the Q&A, Alonso?
Yes.
Yeah, there's a question in the Q&A about if students who are obtaining certification to become, oops, I lost it. I think it was about teachers in one of the STEM subjects could get an H-1B visa. And, to be very honest, I'm not an expert in H-1B visas, but what I do know is that it requires the employer to show that they cannot find someone similarly qualified already in the United States able to work to be able to grant a visa to this person. So it could be very challenging for someone who is getting a certification, teaching certification in one of those topics, if the employer can't prove that there are not already teachers in those topics available to hire in the United States.
Thank you for clarifying that, Sally. A follow-up to you, can you give us some examples as to some of the documentation that individuals might start gathering or that they should be thinking about as they prepare to meet with a legal service provider around, proving that they were here before a certain date? What are some common documents that you would encounter?
Yeah, so there are numerous kinds of documents you'll need to prove for any immigration application. Some have to do with proving, of course, your identity, your date of birth, things like that. The ones that I was highlighting before really are around proving that you were in the United States for a certain amount of time or on specific dates. This is also a common requirement for any application for a green card or naturalization, and will certainly be a requirement for any of the proposals I mentioned earlier, like the DREAM Act, the US Citizenship Act, or currently for DACA. So we have many examples that have been given by the immigration agencies over the years. I can again paste into the chat when I'm done talking some lists that we have with ideas. There are things like, when you think about just how would you prove that you're in the United States right now, it could be things like bank accounts, leases, rent receipts. These can often be challenging for undocumented people who don't have the documentation to have a bank account or to be on a lease. And so then you think about other things, vaccination reports, school attendance records, remittances receipts for money sent back home. And we really encourage people to get that now, because as Allison mentioned, for DACA applicants, they have to show that they've been in the country since 2007. That's over 13 years now. And things like bank receipts, banks often don't keep records past 7 years. Processes change, and the vaccination agencies don't keep all the same records. So you want to keep them now for the possible use later. And again, oh, thank you. Someone's suggesting report cards, other kinds of IDs, anything that you attended or went to that you can document that you were here in the United States. And I'll put some ideas or links to ideas in the chat box as well.
Thank you, Sally. That'll be helpful for those that are preparing to meet with an attorney. And just one point of clarity, there's a question in the chat about support to pay for legal service provider fees. Both the CSU and the community colleges, the attorneys are free of charge. The only thing the individual is responsible for is the filing fees. So you can meet with the legal service provider as often and as frequently as you need, with no money coming out of pocket for you. The only thing that, again, you will have to pay for is whatever filing fee that is to USCIS. So if you're applying for DACA, you would be responsible for paying the DACA fees, naturalization fees, and anything associated with the federal government. But the attorneys are committed to seeing your case from beginning to end, regardless of when your affiliation ends with either the CSU system or the CCC system. If you have any more questions around that, and I'll let Anna speak a little bit more on that, but if you have any questions regarding the legal services project with the community colleges, please feel free to connect with me, and I can help navigate in any issues that you may have.
Right. And I want to add, for the Cal State system, this service is provided, like Alonso mentioned, free of charge, and it's free of charge to our campus students, our auxiliary staff members. So they're part of the auxiliary services, our state employees, and then the families of our students. So any of the immediate members from our students, they will also get these services free of charge. And again, it's so important that you go visit our website to make sure that you know what is the attorney or the agency that's servicing your campus. Thank you, Alonso.
Alonso, could I just add that if people are also wondering about how to pay for the application filing fees, which, in the case of DACA is $495, and so it's going to be hundreds of dollars. There are sometimes opportunities to get grants and or a loan. And one common nonprofit that people seek out is Mission Asset Fund, which has immigration filing fee loans, which is a 0% interest loan. And I could put the link to that in the chat box as well.
Thank you for that information. And those of you that are on this call, In our follow-up email, you'll automatically be entered into our undocumented student support newsletter, and that's also a form where or a vessel of communication that I use to send out information when fee services are available. So if Department of Social Services makes funding available for DACA renewals, once again, that information will go out as quickly as possible. Please send information to your students as soon as you receive it, because some of this fund is on a first come, first served basis. So we want to make sure that it gets into the hands of our students as quickly as possible. So any mechanisms that you might have in place would definitely be in the best interest of our students, so they can, if they're needing that financial assistance. So again, please continue to send your questions either through the chat box or through the Q&A chat feature. Just going back to just a quick reiteration of what the Biden plan is for undocumented immigrants who are in the ag field.
Oh, this is Sally again. Yeah, there has been discussion about sort of like the DREAM Act would legalize or provide green cards to a segment of the undocumented population. There have been other proposals that have been discussed as well. So the estimate is that there are about 11 or 12 million undocumented people in the United States. Somewhere around 2 million of them are young people who came before they were 16 and have gotten education requirements met here. They would qualify for the DREAM Act. There have similarly been discussions about possibly a bill just for agricultural workers, meaning farm workers, those involved in our agricultural industry, as well as there have sometimes been proposals for essential workers, really recognizing the role that essential workers have played during the pandemic and that many of them are impacted immigrant community members. So those are other proposals that have been floated around that would benefit a percentage, but not all of the immigrant community. The details of any of these still have yet to be worked out, but like every other proposal we've mentioned, they're likely to require being in the country on a specific date written into the law, showing that you've been in the country for a certain amount of years. And in the case of an agricultural worker bill and or an essential worker bill, some proof that you're in one of the industries or jobs that qualify for that particular program.
Thank you, Sally. And I believe this one's also for you. Can you share a little bit about what the current approach is to unaccompanied minors at the border?
I apologize. I actually don't know. I don't know if either of my colleagues know. I have not been following that close enough.
Thank you. We'll do some research and be able to provide an answer to this question. Unless I see Allison, you might have an update.
Unaccompanied minors are still put into the custody of what's called the Office of Refugee Resettlement. So family separation is when a minor enters with a parent and they are detained separately. That system has been terminated. That policy has been terminated. But if a minor comes alone, they can be detained, but they are not detained by ICE and the regular detention system. It's through the Office of Refugee Resettlement, which has different systems of keeping children in different facilities that are specifically for children, kind of foster care settings, and then releasing those children eventually to sponsors, whether they family members or other acquaintances here in the United States. It's a pretty complicated system. It's a little bit in parallel to the general immigration detention system. It's very fraught, far from perfect system. So we might be seeing some changes about that as well.
Thank you, Allison. So I think we're coming up to, that was our last question of the day. I know we all have so many questions, so many individualized questions. And again, I encourage you all to connect with a legal service provider provided by either the CSU office or the Community College Chancellor's office. They will be able to answer your questions. You'll be able to do a deeper dive and analysis as to any other forms of relief that you might be available for. All of these services are free of charge so long as you're affiliated with either the CSU or the CCC system. I can't stress this enough. It's imperative that you connect with them. Every case is unique, and we don't want to jeopardize any possible relief fund or options that you may have available. So again, we'll share out all of the links to both the CSU and the CCC legal service providers. Find one in your area, schedule an appointment, and they'll be able to walk you through step by step what you'll need to do for advanced parole, for if you're eligible to apply for DACA, if you're eligible to apply for naturalization, legal permanent residency, the such. And they'll be able to guide you through any possible fee assistance as well if you're eligible for that. Once again, this webinar was being recorded. The recording, along with today's presentation, will be available to you all in the next couple of days. You'll receive this in your inbox through the email address that you used to register today. So again, thank you to our panelists for providing some great insights and updates. And if there are any closing remarks that they'd like to make, I'd like to bring them up now. If not, thank you all for participating. We appreciate the engagement. We're all here to support each and every one of you through this hopefully new era and administration. Enjoy the rest of your afternoon, and please let us know if you have any questions.